Surprised to learn that that's a picture of the Aletto truck and the crane between which Mr. Jordan was pinned.
What's going on, everyone? Welcome back to Trucker 219. So today we got a really interesting deposition of a safety director over a company, and he's getting deposed for an accident that involved one of his drivers and another driver, in which one of the two drivers got pinned in between two semi-trucks and sustained some serious injuries. You're not going to want to miss this. Let's go.
And at this time, the court reporter, Missy Leonetti, will swear in the witness.
Would you raise your right hand? Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Give your name for the record, if you will.
James Vaughn?
Do you go by Jim?
Yes.
Where do you work, Mr. Vaughn?
Joseph Aletto Transfer.
And how long have you worked at Joseph Aletto Transfer?
About 37 years?
Joseph Aletto Transfer is a trucking company, right?
Yes.
You're a director at Aletto, isn't that right?
Operations Director.
Have you also been called the safety director?
It's under the responsibilities of the Operations Director.
So that's among your responsibilities?
Yes.
What do you do as the safety director?
You mean as the Operations Director?
Well, sure. What are your responsibilities associated with your duties as the safety director, which I understand is part of being the operations director? Excuse me.
Okay, so I work in the corporate office in New York, communicate with our operations managers throughout the country on various issues, whether it's safety, operational issues, home delivery issues, tractor-trailer issues, customer relations.
So it sounds like this guy he handles all the issues over the trucking company. If there's any problems, people come to him.
You have some responsibility for risk management, I think. Is that right?
Yes.
Tell us what risk management is.
Well, I work with the insurance companies, and in addition to that, my office and my group is responsible for vetting any new employees, background checks.
Well, he said his office was responsible for vetting drivers, so it might not just fall on him. It might fall on the whole team. So I'm not sure exactly what his responsibility is within the company, but we'll find out here.
Involved when an Aletto truck has been in a crash, right?
Yes, I would be involved with that as well.
Okay. At the time of this collision, tell us how many trucks Aletto owned or operated.
That would be August of 2015, I believe?
September 3, 2015.
Okay. Say around 300.
Whoa, 300 trucks. That's not a major carrier, but that's a big company. I'd say anything over 100 trucks is a pretty big company. Obviously, it's not a mega carrier like your Warner or your Swift or anything like that that's operating thousands of trucks. But it's still a pretty large company. I wouldn't still call that like a mom and pop local company. You know, this is a big company that he's over here.
Operated in 30 states or so, is that right?
We had offices in 18 states.
Whoa, 18.
Some of our trucks traveled through several other states.
Would it be accurate to say that Aletto operates through offices located in 15 states and had a service reach extending beyond 35 states?
Yes.
You said your office was in New York?
Yes.
In the city or here on Long Island?
On Long Island.
And do you live here on Long Island?
Yes.
We are here in Long Island taking this deposition today, right?
Yes.
Have you given a deposition before?
Yes.
How many times?
Half a dozen or so.
Is that all in connection with your work with Aletto?
Yes.
All in connection with crashes involving Aletto trucks?
Yes.
Okay, so he's been in depositions before about 12 other times involving semi-truck crashes, all with this company. So, I mean, I get it, 300 trucks, there's bound to be some accidents there. Just the odds and the ratios that are involved in that, of course, there's going to be some accidents. So he's had to come in here and talk to these lawyers multiple times, so he knows what he's doing.
I want to ask you about some responses that Aletto gave to the written questions that we've exchanged in this case. You've probably heard of interrogatories before.
Yes.
All right, I'll show you now
Yeah, we seen on the last time we did a deposition of a truck driver, the interrogatories are questions that are sent to his lawyer that the lawyer asks him and gets the responses from, and that's all communicated back and forth behind the scenes with the lawyers.
I'll mark as Plaintiff's Exhibit number 6.
I'm going to interject real quick here just for a quick second. I am doing a giveaway for any new or current members on the channel, and I will be giving away this 8-track of 20 truck driving songs with my signature on the back. And at the end of September, I will select a random member on the channel and send it out to them. So if you'd like to do that, the link for that will be down below. Let's carry on with the video.
That this is a copy of Eleto's interrogatory responses in this case. And as you probably already can figure out, what happens here is that the plaintiff, that is my client, asks a question in the regular font, and then the bold below that is going to be Eleto's answer. Does that make sense?
Yes.
Turn with me, if you will, to page 9 and interrogatory number 22. You'll find it highlighted there. And that says, the question was, does Joseph Eleto Transfer Inc. accept any responsibility for the wreck? And the answer was no. Did I read that right?
You read that right, yes.
Do you stand by that?
No.
All right.
Okay, so he looked over to his lawyer to make sure he could answer that question, basically, and now he's not standing by that answer. So let's see how this plays out.
Because this individual who had the accident was operating under our authority, and therefore we're responsible.
Okay. Does Eleto accept responsibility for Mr. Jordan's medical bills arising out of this collision?
Objection. Calls for a legal conclusion.
Okay, so he did accept some responsibility, which is really big for a trucking company. Generally, the best course of action is to not claim any responsibility until you absolutely have to. And it looks like that's what happened here with his interrogatory questions. And that's mainly because there might not be enough evidence to assume fault. And that's why when you are in a truck accident or a car accident or any sort of accident, you don't automatically run up to the other person. Oh my gosh, I'm sorry. I can't believe I did that. Oh, I'm so sorry. Are you okay? Is everything all right? You know, you're expressing that you are at fault by doing that. The best course of action to do is check on everybody, make sure everybody's all right. Start putting people into motion to, 1, call the police, 2, if there's other medical, like nurses that happen to drive by, you know, get them there to help out. You know, just control the scene, you know, watch out for other cars, block everything off that you can, but don't go running and saying, oh my God, I'm so sorry, I'm sorry, that's completely my fault. You never assume responsibility until you have to. If you're on the scene of an accident, take as much pictures as you can and just handle it as it comes. I know it's super stressful, been there, done that.
Does Eleto accept responsibility for Mr. Jordan's medical bills arising out of this collision?
Objection. Calls for a legal conclusion.
If there's any lawyers that are listening to this, what does cause for legal conclusion mean? Matter of fact, let's figure that out on our own. We got the internet. Let's go ahead and ask our good friend ChatGPT.
An objection to a legal conclusion typically happens during a trial or deposition. Deposition, when one party disagrees with the other party's attempt to provide an opinion or judgment that is considered outside the scope of what the witness can testify to. In this context, legal conclusion refers to a statement where someone is trying to apply the law or make a legal determination, rather than just presenting facts.
Okay, so it sounds like if this guy were to claim responsibility for any of the injuries, that would automatically determine that they're 100% responsible for all of that versus presenting the facts of the case and letting the judge and or jury decide.
I believe you can go ahead and answer.
I couldn't answer that question. I wouldn't know the answer to it.
Okay. Well, do you know whether Eleto accepts responsibility for Mr. Jordan's pain and suffering caused by this collision?
Objection. Calls for a legal conclusion.
I'm not an attorney.
Do you know?
No.
Do you know whether Eleto accepts responsibility for the changes to Mr. Jordan's life that have been caused by his injuries as a result of this collision?
Same objection.
Again, no.
No, you don't know?
No, I don't know.
Okay, so they're basically trying to trap him there. It's not quite as intense as what it was with the truck driver. They're very direct about it. Instead of just presenting the facts to this guy and getting him to respond, which would invoke his response of being responsible. It seems like they're just taking the direct approach and asking, hey, do you want to claim credit for this thing here or what?
Was the driver of this truck at fault for the collision?
Our driver?
Yes.
I'm not sure who was at fault at the time of the accident.
You don't know who was at fault.
That's correct.
Now, this collision, I think we've said, occurred on September the 3rd of 2015. It's now March of 2017, and you still don't know who's at fault for the collision.
I mean, I wasn't there, so I didn't see it happen.
Well, you investigated the collision, right?
My folks in Stone Mountain did, yes.
And you were in charge of investigating the collision, weren't you?
No, the folks in Atlanta on scene would have investigated the collision. I would have received the documents, the accident report, and forwarded it on to the insurance company.
I mean, this is a fair point. He wasn't there. He couldn't tell who's at fault. The only people that really could tell who's at fault is possibly the police officers that arrived on the scene. You know, they can do an accident reconstruction and figure out who was at fault and make a determination on that. But this gentleman right here has no idea. He's in New York and the accident happened in Atlanta or something. He has no clue.
Plaintiff's Exhibit 6, which is the interrogatory responses that are in front of you there. And turn with me to interrogatory number 7, which starts on page 3. And I won't read the full paragraph under the number 7 there, but it basically says identify people that have the positions described below. And flip then to the next page, number 4, and look at letter J, which is highlighted there. It says persons who investigated this collision, Jim Vaughn. Did I read that right?
You did.
All right. And in the days after this collision, you were...
So that wasn't evidence from like anything other than the interrogatory question. So, I mean, it's saying that he investigated it, but it seems like the lower people on the totem pole are putting that back up on him, which, you know, the further away you go from the incident, the less accurate the information is.
trying to figure out what happened and investigating it, weren't you?
After the collision, the responsibility is for the local manager to complete an accident report, forward it to our office in New York. We take a look at it and then forward it to Van Liner.
Well, I'll just go ahead and show you the document then. I'll show you what I'm going to mark as Plaintiff's Exhibit number 7, which your company has produced or given to us in this case. This Plaintiff's Exhibit 7 appears to be an email exchange, right?
Yes.
And if you, it's only a 2-page exhibit. If you flip to the second page, we see an email from you, right?
Yes.
And that email is dated September 10, 2015, right?
Yeah.
Okay, so this says that he was issued a citation for following too closely. I'm assuming they are talking about their driver. Both vehicles stopped at light. OV driver exited the cab to check load in rear. IV driver foot slipped off brake. IV truck made contact with OV driver whose arm was pinned between IV truck and OV load logs, possibly sustaining fractures. OV driver transported to hospital via ambulance. Okay, so I'm not sure what this IV and OV means. It says OV driver exited cab to check load in rear. IV driver foot slipped off the brake. IV truck made contact with OV driver whose arm was pinned between IV truck and OV load. Okay, so I'm guessing OV is the truck driver, IV is the vehicle driver, unless of course they're both truck drivers, which is completely possible. So if that's the case, OV could be the other party as well. So let's play this out and see what happens.
It sounds like that'd be 7 days after the collision, right?
Yes.
In fact, the subject is September 3, 2015 accident, right?
Correct.
This says that, who's this email to?
Katie Booth.
And who is she?
I believe she works for Van Liner.
Van Liner Insurance Company, a defendant in this case?
That's correct.
They just said Van Liner Insurance Company is the defendant in this case. So it's not necessarily this trucking company that's the defendant. It's the insurance company. So basically, the injured parties are going after the insurance in order to claim the funds that they need to pay for a broken arm, it seems like.
In this email that you had just spoken with Antoine Billings, right?
Yes,
And Billings is the name of the driver who collided with Mr. Jordan, isn't it?
yes,
And you went on to describe what happened in the collision, right?
yes,
Here you say he was, you talked about a citation in the case, correct?
yes.
And then it goes on, and you have some language here. We don't have to go through all of it, but it refers to an IV and an OV. And I want to ask you what those mean. What does IV mean?
Insured vehicle.
So that'd be the Aletto truck.
Ah,
And OV, is that other vehicle?
That's correct.
And that'd be
Okay.
the collision that, the vehicle that Mr. Jordan was pinned against in this case, I guess.
That would be the other vehicle.
okay. So OV means not their company. IV means their company.
This talks about how the Aletto driver had his foot slip off the brake, hit the other vehicle driver whose arm was pinned between the truck and may have sustained a fracture.
Got it. So it was another truck driver in front of their driver who set his brakes, got out to check the load. He was behind the truck when their truck driver, IV, foot slipped off the brake, he claims, and he got pinned that truck driver in between both trucks. Absolutely crazy. That would terribly suck.
I asked you earlier who was at fault for the collision, and you've answered, so I won't ask you again. But I will ask you this. Do you have any reason to think that Mr. Jordan bears any fault for this collision?
Object to the form calls for a legal conclusion, but go ahead.
We still don't understand why he would have gotten out of his truck in the lane of traffic and gone behind his truck to check a load, why he wouldn't have pulled off into a parking lot to do that. So we find that kind of unusual.
Yeah, that does seem weird. If you got to check your load, pull off into a parking lot. Be safe, not on the side of the road. I mean, obviously, if something breaks free, you got to stop as soon as possible. Otherwise, it could cause more issues. But get to the safest place you can possible. Don't be pinning yourself or putting yourself in a position to get hurt in between two vehicles, especially in a lane of travel. Not only did the truck driver that was right behind him have an issue, it could have been something else even further behind. We've seen in plenty of the crash reactions that we've done, 5 cars back, there's a truck that hits those trucks, which hits those trucks, and it's a domino effect. You're putting yourself in a lot of risk getting out in the middle of traffic, whether it's at a stoplight or not. Don't do that. Be safe. Get in a parking lot.
That's not something that normally truck drivers would do in traffic.
Do you think Mr. Jordan is at fault for doing that?
Object to the form. Go ahead.
I would say he made a poor decision to check his load in a traffic lane.
Well, what evidence do you know of that suggests that Mr. Jordan is at fault for the collision?
Objection calls for a legal conclusion. Subject to that, if you can answer, go ahead.
I don't know how to answer that question.
Well, did you learn something from the police officers who investigated the case, suggesting to you that Mr. Jordan was at fault?
No.
Did you learn something from the medical records, suggesting that Mr. Jordan was at fault?
No.
The truth is, Mr. Vaughn, to the best of your knowledge, you don't know of any evidence held by any defendant suggesting that Mr. Jordan was at fault for this collision. Isn't that true?
If you can answer, go ahead.
Only that his actions were unusual.
Instead of getting him to own the mistakes that happened, he's switching it up and making it to where the other driver has no responsibility for it either. So it's kind of a reverse way of getting them to admit fault, where he's basically saying that other driver didn't do anything wrong either, but that means that if that person didn't do anything wrong, then the responsibility is on their driver. Interesting way to go about that.
Let me show you a document that I'll mark as Plans Exhibit number 8. Have you heard of requests for admissions? It's kind of like interrogatories that we went over a minute ago.
Yes.
All right, that's what I'm going to show you. These are requests for admissions in the case that your company has answered. And it works much like the interrogatories. There's a number and then a statement made by my client through me, and then your company either admits or denies or responds. And there's two responses here because there was an initial response, and then earlier this month they changed the response, and that's called an amended response here. I want to ask you to flip to the second page of Plaintiff Exhibit 8, and it has 39 at the top. Do you see that?
Yes.
And the statement is, plaintiff was not at fault for the collision. Did I read that right?
You read that right.
The initial response there says deny, right?
Yes.
And then under that, there's an amended response, some of which is highlighted, and that says, quote, for its amended response to request to admit number 39, defendant Ileto states that based on the information presently available, it does not have any evidence showing plaintiff was at fault for the collision. As such, defendant Ileto admits in part, denies as written in part, request to admit number 39.
Okay, so it seems like the original response was, it's a double negative here because it says plaintiff was not at fault for the collision. They deny that, meaning that the plaintiff was at fault for the collision. And the amended response is basically saying that based on the evidence, there's no way of showing that the plaintiff was at fault for the collision. So it changed the answer basically to where the plaintiff was not at fault. Did you see the double negative there, though, the not and then deny? So it means that they would have been at fault on that original response.
You read that right.
And that's dated March 15th, correct?
Correct.
That had been last week, I think.
Correct.
Have you seen that before?
Oof.
No, sir.
Well,
Could you imagine being pinned in between the back of this and the front of that? Oh my gosh, that sounds awful.
surprised to learn that that's a picture of the Ileto truck and the crane between which Mr. Jordan was pinned.
Surprised?
Yeah. Would you be surprised to learn that?
No.
Any reason to dispute that?
No.
Do you see that little dent on the bumper of the truck?
Oof.
Yes.
I didn't even notice
Would you be
that.
surprised to learn that's where Mr. Jordan was pinned?
Oh my
Yes.
gosh.
You would be
So it came into such a contact that it bent the bumper. Oh my goodness.
surprised to learn that.
It sounds like that driver's all right, but he clearly sustained some injuries.
Yeah, based on this picture, I would be.
Why would you be surprised to learn that?
Well, looking at this picture, the crease in the bumper appears to be previous to the accident because it looks like there's some rust there.
Did you speak with the officer who investigated this wreck on the scene?
No.
You know, have you ever tried to make contact with Officer Peevler?
No.
Peevler, that's Peavler. Have you spoken with the medical first responders who came to the scene of this collision?
No.
Have you spoken with anyone who was on the scene of this collision when it happened other than Ileto's driver?
No.
Let me ask you this. Do you have any reason to believe that a mechanical or maintenance problem with the Ileto truck contributed to this collision?
No.
How many times did you speak with Mr. Billings, the driver of the Ileto truck?
I can't recall specifically. Maybe 2 or 3 times.
All right. Did he ever mention any mechanical or maintenance problem on the truck to you?
No.
Well, did you know, and when we say you spoke with Mr. Billings 2 or 3 times, I'm talking about speaking to him about the wreck after the wreck. Is that what you understood my question to be?
Post-accident.
Right.
Yes.
Okay. Did you know that once this legal case got started, Mr. Billings suggested that the brake pedal was worn, and that's why his foot slipped off of it?
I heard that.
Who did you hear that from?
Mr. Billings.
Oh. Well, when did he say that?
Can't recall.
Okay. Well, it wasn't in your initial conversation with him, was it?
Again, I don't know which conversation it was specifically.
Well, let's look back at that email that you sent, and I misplaced my copy of it.
Okay, so the driver that pinned the other driver between the car, their driver basically was saying that the brake pedal had some wear on it and it was slippery, and that's why, his foot slipped off of the brake. Sounds like the driver was trying to find any reasoning. Obviously, if you hurt somebody, you're in a load of trouble. So I get it. I don't know if that would hold up or not.
Your email to Ms. Booth with Van Liner doesn't say anything about the brake pedal being worn, does it?
No, sir.
And this email was after your first conversation with Mr. Billings anyway, right?
I would imagine.
Well, it has to be, because the email says, I just spoke with Antoine Billings, right?
Okay, yes.
Isn't it true that Eletto, your company, was not aware of any issue with that brake pedal?
So it sounds like they're trying to get evidence against the truck driver at this point, to where there's no evidence of what he's saying to be true because they weren't aware of it. So this just goes to show for truck drivers, if you're doing a pre-trip inspection and you notice something wrong with the truck, document it. Put it in a file, send a text to your dispatch, hey, there's this issue with my truck. And if they choose not to get it fixed at that point, then that puts the responsibility on them for things not happening. Protect yourself, you have to. Otherwise, something like this very well could happen to you, and then you're stuck with not having the evidence that, hey, I spoke up about this brake pedal being worn, and the company didn't do anything about it. I mentioned it 2 or 3 times, and it was still not getting done. And as the truck driver, you don't control what can be done and not can be done. I mean, you can choose to drive or not drive the truck with the issue, but as far as getting it actually done, that's 100% on the company. So protect yourself, document any issues with your truck before you take off for the day. Ideally get them fixed first, but I understand a worn brake pedal isn't normally a huge deal. I mean, it shouldn't be. So that's something that even me, myself, would just continue driving. It shouldn't cause an issue if you can keep your foot on the pedal. It's not a DOT violation to have a worn brake pedal, so DOT violations are really the only thing that I'll be like, no, I'm not driving this truck, it's not safe to do that. But if there's a crack in your dash, or a worn brake pedal, or your cup holder squeaky, those aren't things that are going to be an issue for you driving, typically.
I'm not aware of any issue with that brake pedal. I don't know that anybody else in the organization was.
Well, has anyone else in the organization, to your knowledge, thought that there might be a mechanical problem with the brake pedal?
No.
And consistent with that, I'd like to ask you to pull out those interrogatories again. They're plans exhibit number 6, and flip to page 12. And you can see where I'm going because it's highlighted there. You see 31 in the middle of the page?
Yes.
And that interrogatory says, quote, did any issue with the subject truck, whether a mechanical problem, electronic problem, or defect, cause or contribute to the wreck in any way? If so, describe that issue in detail, end quote, and the answer was, quote, not to this defendant's knowledge, end quote. Is that right?
That's correct.
So that's consistent with what he's
Isn't it
saying.
also true that after this collision, Mr. Billings did not take the truck in for repairs, but instead kept driving and making his deliveries?
What time did the accident occur?
About 12:30.
So his day would have been done by 4, so I believe after the accident, he may have continued with his deliveries. I can't say for sure. That's all I know about that.
Well, have you looked at the GPS vehicle tracking to figure out what happened after the collision?
No, I personally have not, no.
Well, let me show you then what I'll mark as plaintiff's exhibit number 10. I'll represent to you that this was produced by Ryder, the company from whom Eletto got the truck. Now you see that Ryder 0036 stamp in the...
Okay, so what that means is that they're leasing their trucks from Ryder. They're not owning their trucks, they're leasing the trucks from Ryder. Lots of companies do this. They're basically turning over trucks easier. A lot of the major carriers do that, not necessarily with Ryder. The major carriers typically get a deal with the actual manufacturer where they'll get 500 trucks, and then after a year or so, they'll flip them over and get the next model, and so on and so forth. But this is like it looks like detailed stops and mileage. So the writer has tracking on the trucks as well. It looks like, obviously, if somebody doesn't pay their lease, they got to come collect their truck. So it makes sense for them to have tracking.
And then at the top left, it says Ride Smart, correct?
Yes.
All right. Well, this exhibit has a whole bunch of pages, almost 30. And it goes through, I'll just represent to you, September 2nd at midnight through the end of September 4th, but we're not interested in all that. If you'll flip with me to page 16 of 29, now there's you can see on the right, there's a list of the approximate GPS location, and do you see the third one down, which is highlighted there, says 5993 Peachtree Parkway Northwest.
Yes.
You see that?
Yes.
Do you understand that to be at or near the site of the collision?
I don't, but
Any reason to dispute that?
no.
And then if we go all the way left, we'll see the date and time is September 3, 2015, date of the collision, at about 12:34 p.m. Do you see that?
Yes.
Now, if we look down after that, we can that the truck keeps going. It's all through September 3rd to the end of the day. It goes on for several pages. The truck is still out, moving around, and apparently making deliveries. Does that appear to be correct?
Yes.
Let's take it back so we can see the blown up version here. But it looks like these 3 locations, or these 4 times, are the same. So effectively, stop time, idle time, and then there was traveling on the last one. So these 3 right here were the amount of time that he was stopped for. I'm sorry, these 2 here were the amount of time he was stopped for. So that's a grand total of 12 minutes that he was stopped for. Especially with an accident with injuries, that don't make sense at all just based off of this.
Any reason to dispute that?
No.
And then if we go all the way left, the truck keeps going. It's all through September 3rd to the end of the day. It goes on for several pages. The truck is still out, moving around, and apparently making deliveries. Does that appear to be correct?
Yes.
And we can see if we flip to page 23 of 29, 5th line down, the truck continued moving around until a little after 10 o'clock p.m. on the night of September 3rd, 2015. Is that right?
Yes.
Drivers are supposed to make daily inspections of the trucks that they drive.
Yes.
And they're supposed to create something called vehicle inspection reports, right?
Yes.
That's required by federal law, right?
Yes.
And then it's also something that Eletto tells its drivers they're supposed to do, correct?
Yes.
And we'll show you an exhibit about that. This will be plaintiff's exhibit number 11. Is some of Eletto's training materials, right?
This is part of the driver qualification file.
Is this part of the training materials that Eletto uses?
It's part of the driver qualification file.
Tell me what you mean by that then.
When a driver is hired, there's several documents that he completes, and this would be one of them.
This is one that Antoine Billings created, apparently from the date on the bottom, about a week before the collision on August 25th of 2015.
Correct. That's probably the day he started completing the DQF.
Okay, so driver qualification, how long did they say it was? Hang on, let's take this back.
This is one that Antoine Billings created, apparently from the date on the bottom, about a week before the collision on August 25th.
Ah, okay, so this driver was a new hire for them. If it was a week before the collision, that when he's hired on, they have to fill out all these papers, which you guys will deal with if you got to go to orientation. You got to sign a bunch of stuff that says that, basically that if something happens, you've been issued the rules and regulations of the company, so on and so forth. But it was only a week prior to the accident that this driver had signed this. That means that he had just started with this company less than a week ago, or about a week ago.
Correct. That's probably the day he started completing the DQF.
Driver qualification file?
Yes.
And if we look there at the top, I've highlighted what I'm interested in. It says every driver must prepare a vehicle inspection report in writing at the completion of each day's work on each vehicle he or she operates. Is that right?
Yes.
And that vehicle inspection report is supposed to cover several things, but the very first one listed is the service brakes, right?
Yes.
Service brakes just means what most drivers would call the regular brakes, the one you hit with your foot if you want to stop, right?
Yes.
Now, where is the driver inspection report for the day of this collision?
I have no idea.
Well, have you looked for it?
I personally have not looked. Maybe the staff in Stone Mountain might have. And had they found it, I would have produced it, but apparently they didn't.
Again, this is pointing it back to the driver. Number one, he didn't report that there was an issue with the brakes, and number two, he didn't fill out the paperwork saying that there was an issue or wasn't an issue with the brakes. You guys got to keep up with your paperwork. I know it's awful. I absolutely hate dealing with paperwork. Bill of lading, inspection reports, anything paperwork related. I just want to drive the stinking truck. But you got to do it in order to protect yourself.
Did you call down there and ask the folks in Stone Mountain?
I probably did.
Do you remember whether you did that?
No, I don't.
Have you ever seen the vehicle inspection report for the subject truck, that is Billings' truck, on the day of this collision?
I have not.
Well, did you know that Mr. Jordan, through his lawyer, which is me, asked to see that document?
If you say so.
You didn't know that, though?
I don't recall, no.
Okay. Well, I'll show you then what I'll mark as Plans Exhibit number 12. And this is going to be an excerpt from requests for productions, which are a lot like the ROGs and the interrogatories and RFAs that we've been over. Are you familiar with the idea of requests for production?
Yes.
And look, if you flip to the second page of Plans Exhibit 12, which was page 9 to the original longer document, you see 23 at the bottom highlighted there.
Yes.
And that says, produce all post-trip inspection reports or forms for the subject truck from the day of the wreck and the 7 days preceding the wreck. And the answer was, this defendant is not in possession of records responsive to this paragraph. Did I read that right?
You did.
So basically what that means is either A, the truck driver clearly didn't produce them, or B, they vanished into thin air, so there was no proof. My guess is the truck driver didn't do it. Knowing myself and knowing a lot of other drivers, he probably just didn't do the paperwork for it.
And then on the very next page, number 24 asks for pre-trip inspection reports, and the answer is the same. Is that right?
That's correct.
Did you know that your company's lawyers in this case have said they don't know whether Billings ever created that vehicle inspection report that federal law requires?
There it is.
I don't.
Well, I'll show you then what I've marked as Plans Exhibit number 13. And this is a letter, and at the top it says Dennis, Corey, Porter, and Smith, right?
Yes.
That's the law firm that's defending this case on Eletto and Van Liner and Billings' behalf, right?
Yes.
And if we flip to the second page, you can see what I'm driving at here. Number 3, which is highlighted, it says, Billings is not sure whether he prepared a pre-trip or post-trip inspection report. As stated, defendants are not in possession of documents responsive to those paragraphs. Did I read that right?
You did.
Now, isn't it true, Mr. Vaughn, that shortly after this collision, Eletto knew, and you knew, that that vehicle inspection report was an important document to save?
We understand that we're responsible to gather the documents required, especially in light of an accident, yes.
And that included specifically the vehicle inspection report, right?
Yes.
In fact, you received a letter. Well, I guess I'll just mark it. You received a letter shortly after this wreck asking you and your company to preserve that vehicle inspection report, right?
You can show it to me?
I can, sure. Do you remember it?
No.
All right. Then I'll show you what I've marked as Plans Exhibit 14. And this is a letter from the Mabra firm, right? It says at the top.
Yes.
Is to Joseph Aletto and to your attention, right?
Yes.
And then it goes on in here, the highlighted language toward the bottom of the first page of Plan Exhibit 14, to be preserved and not to be destroyed, modified, altered, repaired, or changed in any manner. Is that right?
Yes.
And then number 5 on the list of stuff to preserve includes the inspection reports, correct?
Yes.
Now, did you look for those inspection reports today in advance of this deposition?
No.
When was the last time you looked for them?
I personally never looked for them.
Okay.
Now, I see this letter was sent to our Hicksville address, where we're in Syosset, and we were at Syosset at the time. I don't even recall ever seeing this letter. I may have, but I don't.
Well, anyway, there was a legal requirement to preserve that stuff, wasn't there?
Understood.
Isn't it true, Mr. Vaughn, that Antoine Billings, the driver of this truck, was not very experienced at driving trucks like this?
I don't recall his exact experience. I'm sure that was discussed when he was interviewed locally.
I'll circle back to that in a minute. But this was a commercial truck that Aletto leased to Billings to drive, right?
Yes.
This is the plaintiff's lawyer's words that it was leased to the driver to use. I don't know if lease means it was a lease purchase program or they're misspeaking and saying that, you know, they're letting him use the company's truck. So he would be a company driver. I'm not sure. We'll see how that plays out.
Time of this collision, Billings had just started driving for Aletto like a week or two before, isn't that right?
I believe it was his first day.
Oh.
And before he started driving for Aletto, isn't it true that Mr. Billings had been driving for Pizza Hut?
I'd have to look at some documents to verify that.
Do you remember him being a Pizza Hut delivery driver?
I personally don't know.
This makes it sound like he's scooting around in his car throwing pizzas at people on a Friday night. Pizza Hut has their own truck driving a situation where they deliver from distribution centers to local stores and all that. So this could very well be what that is, but they're kind of twisting it to where it sounds like he's just a pizza delivery guy, which could be the case. I'm not sure, but just to be clear, Pizza Hut has commercial trucks.
Well, I'll show you then what I've marked as Plans Exhibit number 15. And 15 is an excerpt from some materials produced to us in this case. And there at the top, under last job, it says Pizza Hut position was delivery driver, right?
Yes.
Now,
Okay, so normally on those, on the applications, let's back it up here. Normally there's a spot to select whether this job was needing to be in compliance of the FMCSA guidelines, meaning was this a commercial driving job? And I'm not seeing that here on his stuff. There's also a delivery driver section down here, Quest staffing, a warehouse worker. I doubt you're going to go from warehouse to pizza delivery driver, but there's also 2 other delivery drivers. So he very well could be a semi-truck driver on either one of these.
Mr. Billings did not have a commercial driver's license, did he?
No.
Ooh,
And we'll show you what I've marked.
maybe he was a pizza delivery driver.
I'll represent to you that's a copy of Mr. Billings' driver's license produced to Mr. Jordan and his lawyers in this case. Do you see the stamp there, Aletto 000026 in the bottom right?
Yes.
Have you seen this driver's license before?
I'm sure I have.
Okay, so normally if a driver's license is produced, it'll say commercial driver's license and it'll say Class A for a semi-truck. However, Class C is a commercial driver's license, but this is more so for your tour buses, things like that. This is more for a passenger, school buses, anything with bus where you're carrying 16 or more passengers. Class B would be your straight trucks, and you can get an air brake endorsement. And that class is based off of weight restrictions on the vehicle that you can haul. And then Class A, obviously, is the top tier semi trucks, the whole 9 yards. And then if you have a Class B, you can drive Class B and Class C. If you have a Class A, you can drive Class A, B, and C. So this driver has a Class C commercial driver's license, but not a Class A. Very important distinction there.
Well, have you seen any other driver's licenses for Mr. Billings?
No.
This one was no good.
Oh, I didn't even notice that. It expired.
If you look in the top right there, it says this driver's license expired on August 20 of 2015. Isn't that right?
That's correct, yes.
Thank you, Mr. Vaughn. I have no further questions.
Okay, so this is an interesting case. Obviously, this is involving 2 truck drivers. It seems like the company has definitely passed the buck back to the driver, where if there has been any issues, you know, it hasn't had to do with the company. The only thing that I would see that the company would be responsible for is fixing that brake pedal. But if the driver's not letting the company know about the brake pedal, there's nothing they can do about it. And then the second thing is doing a better job of vetting their truck drivers. If this driver came on with an expired license, not a Class A license, he shouldn't have been driving a truck to start with. And also, the company should be requiring that the drivers submit a daily inspection form. So whether or not the driver did or didn't do that, if they are requiring it and he's not doing it, there should be some consequences for not doing it, whether that be getting written up or getting terminated. So no matter what, it always seems like the responsibility does end up falling back on the company because they are not training their drivers correctly to do what they need to do. However, this truck driver seemed to slip off of the pedal and end up crushing another driver in between both trucks, and that's absolutely crazy. However, the driver of the other vehicle should definitely not be getting out in the middle of traffic just to check a load. Pull off to a parking lot somewhere, check your load, make sure it's all good to go. But don't do that in the middle of the road, highway, interstate, whatever it is. That's crazy. That's dumb, and that's a surefire way to get yourself pinched between 2 trucks. So what do you think? Do you think the responsibility of this accident should fall on the driver, the company, or the other vehicle? Let me know down in the comments below. But that's going to be it for this one. Don't forget to like, comment, and subscribe. All right? Bye.